Hello, everyone, and welcome to the Equity Pulse. I'm Cindy Tsai, Executive Vice President and General Counsel at Committee of 100. For those of you who may be new to C100, our mission is to advocate for the full inclusion of Chinese Americans in the United States and to foster constructive relations between the United States and Greater China. One way we advance this mission is through our annual State of Chinese American survey. Through this survey, we have seen a decline in the sense of belonging among AAPIs. That's what led to the creation of this series, The Equity Pulse, where we take a closer look at policies and laws and how they impact our community. These conversations are held on the third Tuesday of each month with the goal of making complex issues more accessible and easier to navigate. Today's topic is birthright citizenship. The Supreme Court will hear oral arguments on April 1st in Barber v. Trump, a case challenging Executive Order 14160, which seeks to end automatic birthright citizenship. This is a complex issue, and perspectives varies across communities. In our most recent survey, 35% of AAPI respondents said they strongly oppose ending birthright citizenship, compared to 51% of Hispanic and Latino respondents. I share this to point out that this issue is often discussed as affecting certain communities more than others. But in reality, the implications are much broader. At last month's Equity Pulse, Queens College President Frank Wu spoke about the importance of this right and stressed that chipping away birthright citizenship is the first place for denaturalization. If you missed that webinar, the recording is available on our website. With that context, we are fortunate to have four outstanding legal professionals to help break down this issue. Before we start, a few quick housekeeping notes. First, we heard your feedback that you would like more time for question and answer. In order to address as many questions as possible, we ask that you submit the question in the Q&A box throughout the session. We will use the questions to guide our conversation. Second, today's webinar is being recorded and will be available on our website in a few days. And finally, at the end of the program, you'll see a short survey. We really do read and use your feedback. Please take a moment to fill it out and share any topics you want us to cover in future sessions. Now I'll briefly introduce our panelists. You could see their full bios in the event page. Wendy Feng is a commercial litigation attorney at Safeguard Shaw and served as counsel of record on the amicus brief filed by the National Asian Pacific American Bar Association in Barber v. Trump. Arjun Shenoy is an appellate attorney, and Tony Wang is a partner at O'Melveny and Myers. They were part of the legal team that worked on the amicus brief filed at the Fred Korematsu Center for Law and Equity. And Jennifer Wu is a founding partner of Groombridge, Wu, Bauman, and Stone. She is deeply committed to public service and has represented victims of anti-Asian hate, as well as filed amicus briefs on matters relating to wrongful convictions. And with that, I'll turn it over to Wendy to start us off with a brief primer on birthright citizenship and Executive Order 14160.
Most people I know are familiar with the concept of birthright citizenship. What that means, and the way that we've all thought about it, is that if you are born in the United States, you have U.S. citizenship. This principle is based on the 14th Amendment of the U.S. Constitution, and it was also later codified by statute through an act of Congress. There was a bill passed in 1940 that essentially says if you're born in the U.S., you have U.S. citizenship. What we're here to talk about today is this executive order before you. This was signed in January of last year, 2025. And what EO 14160 says is basically that it seeks to deny citizenship to certain categories of people who are born in the United States. If you fall into one of these two categories here, then even if you are born on U.S. soil, you are not entitled to U.S. citizenship. And the language here is a little confusing, but what it essentially does is limits birthright citizenship to the children of only U.S. citizens and legal permanent residents, or what we commonly refer to as green card holders. Most of the publicity around this executive order has been focused on the unlawfully present or temporary visitors portion. So that's people who are undocumented in the United States, who are here illegally, and people who are temporary visitors. But what a lot of people don't realize is the language of this executive order is a lot broader than that. It specifically includes people who are in the country lawfully, people who are here on visas, sometimes here for many years. This includes people who are on work visas, people on H-1Bs, people on student visas. And what this essentially says is that if someone born in the United States does not have at least one parent who is either a citizen or a green card holder, they're not entitled to U.S. citizenship. Uh, Now, the government's justification for this and for changing the way that birthright citizenship has been thought of for over 100 years is relying on a specific portion of the 14th Amendment. Next slide, please. What the 14th Amendment's citizenship clause says is, and the full language is here in this slide, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And what the federal government is focusing on is this highlighted portion here that says subject to the jurisdiction thereof. And they are arguing that essentially this means the subject to the jurisdiction of means only people who are U.S. citizens and green card holders. And today we're going to get into a lot more of those arguments, but essentially the basis at the root of the government's position is that the intent of the citizenship clause was to confer citizenship on newly freed free slaves and their children, and not on the children of immigrants. That's what the government is saying. This argument has been made before. In fact, this reasoning was rejected over 100 years ago. For the past 125 years, 14th Amendment has been interpreted as conferring citizenship on anyone born on U.S. soil, except for very limited exceptions, like the children of diplomats, who are literally not subject to the jurisdiction of the U.S. And what we're going to talk about today is a lot of this legal history was actually made in large part through cases involving Chinese migrants and their children. In the late 1800s, when Chinese migrants were living and working in the U.S., a lot of what was U.S. immigration policy at the time was directed at essentially our ancestors, and governing their place in American society. So I'll turn it over now to Jennifer to talk through this history.
Hello, everyone, and thank you for joining us. And thank you to Cindy and Jenny and everyone at C100 who, helped organize this. This is a fundamental and very important question. I think many of us on the Zoom, including myself, I am the daughter of immigrants, and the idea of birthright citizenship has led me to where I am now and being American. And the idea that it could be taken away is a very scary proposition, in the sense that generations of immigrants after us may not have the benefit. I'm in New York City, where some of you might be, and today's actually St. Patty's Day. There's actually a huge parade going by my apartment right now, and sort of ironic that we're celebrating the immigrants that came to the United States at a time when these rights are being threatened. So before I know not everyone on the Zoom is a lawyer, and feel free to ask questions in the webinar if it, things are confusing. But before I leave this slide, I just want to note that the key argument that the government is making is that in the very first sentence, and if you look kind of before the highlight, it says all persons born or naturally in the United States, comma, and subject to the jurisdiction thereof. The key government argument is that the word born is not equivalent to subject to the jurisdiction thereof. That if what was intended was that all persons born in the United States are therefore citizens, it would have said that. That the highlighted language has a different meaning than just being born here. So being born here doesn't confer citizenship, and that you have to look at parental lineage to determine who is subject to the jurisdiction. And the way that kind of like the history of the laws kind of came about, as I think many of you know, there was a long period of the United States where not all people were treated equal. Chinese immigrants, most of all. And the case that I'm putting up here is the case of a Chinese laundromat. Someone tried in San Francisco to get permits for Chinese laundromats, and prior to 1886, Chinese people were being imprisoned for seeking permits or getting permits to run laundromats, and that's purely because of their national origin or their race. And there's a very important case, Yekwo v. Hopkins, that is the predecessor to birthright citizenship that says that you can't deny sort of the application of law or protection of the laws to people because of hostility to race and nationality. But I want to at the same time know that while this is going on, the United States was also in the process of enacting the Chinese Exclusion Act. So it's a time at which the courts are giving sort of protection at some level of the laws, but yet at the same time, the people, like Congress, is saying that Chinese Americans should not be allowed in, and a whole class of people don't have equal rights. This is later obviously followed with Japanese internment camps, Korematsu, all the things that we in the Asian community, have at some level known as discrimination, but it was reality for a lot of people at the time. And I think that at the time that this, kind of going back to Section 1, this was written, there were kind of exceptions that, commonly understood exceptions to people who are automatically citizens. And one of those exceptions was diplomats. So if you were an ambassador and you had a kid here, it didn't mean that your kid automatically got citizenship. Another exception was people who were invading armies. So if an invading army came and, invaded your country and then had a kid, it wasn't clear that that would confer citizenship. And then the third exception is probably a third category, but maybe not limiting, according to the government now, was American Indians because they had their own lands. So it didn't mean that you're automatically U.S. citizens if you're born on Indian land. And so, in my view, the subject to jurisdiction thereof always had sort of an originalist exception built to it. And I want to be clear, these are my views, not the views of my firm. But my reading of it is that the US government now is taking a position that those exceptions are much broader than what they're originally intended to do. And that's kind of sort of like the basis for the government argument. So, as Wendy said, 150 years of unprecedented, kind of unbroken line of precedent that there is birthright citizenship. But I want to just remind people that at the time that the 14th Amendment came about, it wasn't so equal in society. And there were exceptions that were kind of baked into the case law. So following on this Chinese laundry case, there was the kind of preeminent case that's going to get debated in the Supreme Court on April 1st, and the oral argument for this case is also about Chinese Americans. And this case called Wang Kim Ark was basically about whether Chinese persons who were born to, I think, people who are illegally, in the United States, were subject to the jurisdiction thereof, and therefore their kids were citizens. And this is the precedent that Wendy's speaking of, as in the kind of unbroken line of precedent that this is the status quo, that this is how we all understand birthright citizenship, that people who are within the jurisdiction of the state are subject to the jurisdiction of the state. If you are here, you're subject to the jurisdiction. And my view is that that is eminently reasonable. If you're in the United States, you can get pulled over for a traffic stop. You have to pay taxes. You might be subject to, kind of various state laws or federal laws, so you are subject to the jurisdiction. What's happening now is the US government is trying to take a different position as to what that means. But the Supreme Court precedent, I think, is clear just based on the statements that the birthright citizenship kind of aspects that we have in place now are valid and affirmed by the Supreme Court, even at a time at which Chinese Americans were not really considered equal, and there was going to be further discrimination for many, many, many years after that. And I think, kind of one of the things that we tried to do in this next slide was to highlight why it is that the government is trying to embrace this case, even though it doesn't really go the government's way. What the government is saying right now is that the exceptions to the qualifications, and this is what I was talking about earlier, people born on a foreign ship during a hostile occupation, children of Indian tribes, people who owe their allegiance to several tribes. The red language is really what the government is focused on and saying that there's exception to this, kind of automatic birthright citizenship. But the yellow language that follows on these exceptions is very broad and makes clear in no uncertain terms that all children born within the territory of the United States, all persons of whatever race or color domiciled within the United States, are subject to the jurisdiction of the United States and within the allegiance and protection of the United States. So if you were to have asked me, 10 years ago, is this an open question that birthright citizenship is not constitutional? I would have said no way. I would have said it's very clear in the law, based on what's said in yellow, that this is a constitutional doctrine. We're not going to question this. My kids, regardless of whether or not I myself am a citizen, if they're born in the United States, they would be conferred citizenship short of me being an invading army or a diplomat from a different country. But I think we're in a world in which a lot of status quo laws are being challenged. I like to quote Kenji Yoshino, who's a professor at NYU Law, by saying this is the YOLO court. You only live once. And so precedent, whether it's in the form of abortion rights or gay marriage or anything else, are all sort of under question. And I guess we shouldn't be that surprised that it's also under question here. I wanted to point out that there were dissents in Wang Kim Ark that said that people who are born here should not be citizens if they are subject to the political jurisdiction of another country. And that's important because Wendy said that these arguments the government's making have been addressed. I think that's generally correct in that the same arguments were being made in 1898, that if you were politically loyal to China, that perhaps that you should not become a citizen here because even though you're subject to the jurisdiction, you're not subject to the political jurisdiction. There's kind of the Chief Justice at the time, right, believed that Chinese Americans should not be, who are born here, should not be citizens. And so it's not new that Chinese Americans should be excluded, or that birthright citizenship shouldn't be, or that it's under debate. More than 100 years ago, this was under debate, and it turns out it is again now. And that, I guess, that doesn't totally surprise me, given where we are. Just to kind of wrap up what the government said so we can kind of get to the meat of the discussion. The government is saying that children of alien parents who are domiciled elsewhere, only temporary present in the United States, owe their primary allegiance to somewhere else. You're not loyal to the United States. Political jurisdiction is different. The government is also saying that that Wang Kim Ark is different because that concerned children of people who were domiciled here, who are kind of lawful permanent residents here. And so people who are undocumented wouldn't fall within that category, trying to distinguish Wang Kim Ark as binding in this case. What respondents say, which is really kind of the people who are saying, let's keep the status quo, is that the precedent has been unbroken for a long time, more than 150 years, and this is not the time to change the law. There's absolutely no basis for the government's reading that would make sense in view of precedent. And I think these arguments are all very rational. They are what everyone thought would happen. I think that, it's just a signal where we are in terms of the justice system and also the political kind of sway, that we're even questioning whether birthright citizenship is up for debate right now. And so before I turn it over to others on the panel, I just want to comment that there's been a number of amicus briefs that have been filed, and most of them have been in support of respondents. What that means is that it's in support of birthright citizenship staying as they are. And I think, to me at least, and I know we're going to talk about the Napalba brief and other amicus briefs, the most powerful briefs are the ones that talk about the downstream consequences of what would happen if you were to destabilize and change kind of birthright citizenship now. Like, all the kind of parade of horribles that might happen that we'll talk about, I think, have the potential to sway the decision of the court if it's not able to be administered in a proper way. And on the flip side, you have in support of the government, all the usual arguments that public safety, originalism, national security all justify a change in the law, and that it's not really a change in the law because it's what the founders intended, or perhaps it was never ruled on in the first place. So with that, I'll turn it over to Arjun and Tony.
Thanks, Jennifer. It's great to be here with all of you. As Cindy mentioned, part of why we're here is to talk about the amicus briefs that were filed by Napalba and the Korematsu Center in the Trump v. Barbara case before the Supreme Court. So before we get to that, the substance of that discussion, I think it would be helpful to just sort of give the non-lawyers in the audience a quick overview as to what an amicus brief is and sort of what role it plays in litigation. So an amicus brief is filed by an individual or an entity that's not actually party to the case, but who wants to offer the court information or arguments as to the outcome because it might affect them or the public more broadly. So the term itself, amicus curiae, means friend of the court in Latin, but in practice, amici are usually not neutral. So they're typically supporting one side of the case and trying to influence how the court thinks about that issue from that perspective. So these amicus briefs are typically, or especially common, I'd say, in appeals, where the court's often deciding not just who wins the particular disputed hand, but what the sort of legal rule will be that will govern future cases that implicate the same issue. So that's why amicus briefs are so important, or can be so important. They help show the court that the case may have consequences beyond just the two parties that are sort of, so to speak, in the room. So, for example, for NAPABA or the Korematsu Center, we filed amicus briefs sort of explaining why a particular reading of the law, in this case, the 14th Amendment, might impact the civil rights of Asian Americans who aren't party to the case, but who could potentially down the road be affected by a ruling in one direction or the other. Amici can also, I think, provide the court with information that the parties might not be best positioned to provide themselves. So this could be like technical expertise, industry context in certain cases, historical background, which is particularly relevant to the amicus briefs that we're going to be talking about today, policy consequences, as well as presenting empirical data that might influence the outcome. And I think this is sort of generally useful for judges because the people deciding these cases are, in effect, generalists, including the Supreme Court justices in this case. They're often deciding important questions in highly specialized areas, and a strong amicus brief can help translate the real-world significance of the case to the justices, or in the case of courts of appeals, the judges on the panel. The last thing that I think is sort of worth emphasizing here is that amicus briefs can be ignored by the court. They don't have to, the judges who are on the panel don't have to consider them or even read them if they don't want to. And as is often the case, they don't necessarily alter the outcome. I think, practically speaking, the most you can hope for is to provide additional resources for the court to come out in a way that they normally would have in any event. So while it is helpful, it's not dispositive of the case. The party briefs, I think, are going to matter a lot more. And oral argument, which the parties are involved in, that amicus briefs, briefs and amicus curiae are not involved in, that's going to matter more to the outcome of the case. So I'll turn it over to Tony to help facilitate the discussion about these particular amicus briefs filed by NAPABA and the Korematsu Center.
Thank you, Arjun, and thank you, Jennifer and Wendy. Hi, everybody. My name is Tony Wang, and I'm a partner at O'Melveny & Myers. Like Jennifer and like many, I'm sure, on this audience, I'm a child of immigrants, and I would not be here today on the screen if it wasn't for our Constitution, the protection that provides. My parents came to America 60 years ago as students in college, and I think, as Wendy said at the beginning, the way the executive order is drafted, people like me today would not be entitled to birthright citizenship if the executive order is enforced. With that, I want to talk about substance now and kind of dive into the two briefs that were submitted by two organizations who are very active with the Asian American community. The first one is NAPABA, the National Asian Pacific American Bar Association. And I know that Wendy and Seyfarth took a very active role working with NAPABA and many of its affiliates to author that brief. And so, we're now here at the Supreme Court with oral arguments a few weeks away. But this actually goes back to, obviously, the circuit court levels from last year after the executive order was first announced and then brought to the Supreme Court thereafter. So with that, I'm going to turn to Wendy to kind of frame the discussion and how NAPABA viewed this issue and how they assembled this amicus brief to influence the court, as Arjun talked about just now.
Yeah, so first of all, as everyone else has expressed, this is an important issue. Unlike my co-panelists here, I think I'm the only one here who does not have birthright citizenship in the US, and that's because I'm not even a US citizen. I'm a green card holder, like so many of us in the Asian American community. I'm a first-generation immigrant to the US, and that's a big part of what made this so personal and important to me. NAPABA, as many of you may know, is the National Asian Pacific American Bar Association. Is an organization of about 80,000 lawyers and judges of Asian American descent across the country. And of course, so many of us in this community are immigrants or the children of immigrants. Many in the community are visa holders on student visas, work visas, and there are just, we all know people who are directly impacted by the executive order. So I think NAPABA's view and all of these affiliates that signed on to our brief wanted to represent the Asian American community and the unique historical perspective that's presented by this community as it relates to this issue. So what the NAPABA brief specifically speaks to is the Wang Kim Ark case that Jennifer talked about earlier. Specifically in the Wang Kim Ark case, the U.S. government is arguing that Wang Kim Ark's parents were domiciled in the U.S., so they were the equivalent of today's legal permanent residents. So they were the equivalent of today's green card holders. That's what the government's arguing, and that is their justification for carving out these other exclusions. So what NAPABA's brief walks through is actually the historical context of Wang Kim Ark. That decision in 1898 followed a period of time when there was very strong anti-immigration sentiment, specifically towards the Chinese migrant community. At that time, there were a lot of Chinese migrants who had moved to the U.S. to work, and they formed these little communities. And there was widespread racism and violence against the Chinese community, riots and looting, and many Chinese people were forced from their homes, attacked, and even killed during this time. So what our brief talks about this historical context, and what we argue is that at this time when anti-Chinese sentiment was so strong in the U.S., this notion that Wang Kim Ark's parents were the equivalent of today's green card holders it's just not a good analogy. They did not have any of the same rights, any of the same protections, or any of the same sense of belonging legally or socially that today's legal permanent residents have. And so what we argue is that, to the contrary, what Wang Kim Ark actually affirmed is this fundamental principle that the right to citizenship enshrined in the 14th Amendment cannot be revoked on a whim, and that regardless of the popularity of anti-immigrant sentiment or the leanings of a particular presidential administration at any particular point in history, you cannot just revoke the right to citizenship. And in fact, Wang Kim Ark, in our view, tested the strength of the 14th Amendment at a time when strong anti-Asian immigrant sentiment resulted in a systematic effort to push Chinese migrants out of the United States. And even within that socio-political context of that time, the Supreme Court in 1898 held that Wang Kim Ark had a constitutional right to citizenship. So given that context, what NAPABA and its affiliates that signed onto this brief are saying is that the children of immigrants born in the United States today should have the same protections.
Thank you, Wendy. I mean, essentially, the idea that the parents of Wang Kim Ark were somehow green card holders was quite illusory, right? I mean, they were not at all kind of settled in America. In fact, they went back, right? So this was
exactly.
Yeah, and yet their child was guaranteed that.
But I want to just say, like, I think what Wendy's comments elucidate is that if citizenship is conferred based on who the parents are, it creates potential that certain classes of people will benefit and certain will not, right? Because you can judge certain parents as being from better countries than others, or Chinese were not.
Yeah, certainly, again, historical context is important here, and I think that's what NAPABA brings to the table with the amicus. So that was kind of historical aspects. Now I'm going to turn it to Arjun and how we got involved. With O'Melveny, the Korematsu Center, which is at UCI Law School here in my backyard. For those who don't know, I mean, Fred Korematsu was very famous for his own personal challenge of very negative executive order by President Roosevelt back in World War II. And since then, the Korematsu Center has been at the forefront of civil rights litigation, filing many amicus across the country, working in concert with the Asian American Legal Defense Fund, various universities and other nonprofits. Arjun, you and I worked closely with our Supreme Court appellate head, John Hacker. We worked with Professor Chang. We worked with Aldef. Can you shed a light about how we took kind of different tact at looking at this executive order and kind of the real world implications of what it would mean for people who might be denaturalized or otherwise affected negatively?
Sure. So I think if I were to describe the two main goals of the Korematsu Center amicus brief, I think one goal sort of dovetails with what Napalma was trying to do in the sense that we wanted to shed some light on historical context, but talking about examples beyond the Wang arc. So one example for the South Asian community in particular was what happened after the Supreme Court's decision in United States versus Thind, which was in 1923. This was a case that basically declared that South Asians were racially ineligible for citizenship. And as a consequence of that, the government launched denaturalization proceedings against more than 50 Indian Americans who at the time had already become citizens. So we wanted to highlight that history, sort of explain how this isn't the first time Asian Americans, and I guess in particular South Asian Americans, have been subject to government efforts to denaturalize or citizenship strip more broadly. But as you mentioned, Tony, I think the other goal of the brief was to sort of focus on the real world consequences of an executive order like this being implemented. And the way we tried to do that was to use present day interviews that were taken by one of our partner organizations, ALDEF, to sort of show how citizenship shapes life's chances in very concrete ways, using examples of Asian American mixed status families. So these are families where you might have one child who is undocumented and another child who is a citizen and gets to benefit from the fact that they are citizens. So we use sort of case studies, so to speak, to explain how there's a big difference in a child's ability to access, a proper education, to be able to work legally, travel, vote, make long-term plans without fear. These are real practical consequences to having citizenship. And another thing that the brief tried to focus on as well was that if the executive order were upheld, or if the Supreme Court took the view that birthright citizenship was limited in the way that the government's advocating, it wouldn't necessarily mean that the effects would stop with the federal government. So if the constitutional foundation of birthright citizenship is weakened, states and localities, for example, might start questioning people's citizenship in a way that affects their ability to vote or their ability to serve on a jury. So it's in the Constitution itself that states have a lot of latitude to determine voter eligibility requirements, particularly for state and local elections. So if there were a decision that limited the scope of birthright citizenship, states and localities might be able to use that decision as a basis to say, certain individuals who otherwise would qualify for jury service, for example, no longer qualify because they aren't, citizens in the way that they otherwise would have been prior to the Supreme Court's decision. So I think that's the bottom line message of the brief was that weakening birthright citizenship wouldn't just be some sort of narrow doctrinal change. I think it would risk reviving old patterns of exclusion and destabilizing the lives of people who have otherwise always understood themselves to be Americans. And we used examples of Asian Americans to sort of bring that point to life.
Yeah, the example you said with U.S. versus Thind, I mean, that was one where you had South Asian Americans who were actually military veterans, right, who were served this country proudly, and yet because of the interpretation were denaturalized, leading to very difficult circumstances. Well, with that said, I mean, again, I appreciate both Napalma and the Korematsu Center for all the work. Obviously, as Jennifer mentioned, there were numerous briefs submitted on both sides. I know we have questions. I see questions already in the Q&A box, which I'll get to in a bit. But I want to kind of think about how we expect this court to kind of analyze the case. Obviously, the oral arguments are in 2 weeks or so. You can see them on live feed. You can't see, you can listen to them. You can hear them on live feed. But maybe I could have Arjun maybe help frame kind of what are possible outcomes. I mean, the court is going to take, the oral arguments in person, live. They're going to then evaluate. What are some of the ways we could think about regarding the decision-making process. And then I'm going to turn to Jennifer to get some of the kind of inside baseball or inside football type of analysis as well. But Arjun, maybe you can frame that discussion.
Sure. So I think broadly speaking, there are three possible outcomes. So two of them are fairly straightforward, and one of them might be mixed. So the first outcome is that the court could just strike down the executive order in its entirety. I think the logic there would be like there's 14th Amendment's text, as well as the longstanding understanding of Wang protecting birthright citizenship for virtually all children who were born on U.S. soil, regardless of their parents' immigration status. So the president, through an executive order, can't narrow the scope of the 14th Amendment's birthright citizenship. And if you wanted to do something like that, it would require a constitutional amendment. Another possible outcome could be upholding the executive order. So the court could accept the government's argument that the citizenship clause doesn't extend to at least the children who are identified in the executive order, and that executive order is consistent with the original meaning of the term subject to the jurisdiction thereof in the 14th Amendment. So as it's sort of been mentioned already, a ruling like that, I think, would mark a major shift in constitutional doctrine and would permit the federal government to deny citizenship documents to at least those categories that are identified in the executive order. And they could push the envelope further, but at the very least, it would cover those categories. The third outcome could be a narrow or sort of mixed ruling. As mentioned earlier, the executive order covers two categories. So there's one category of children born in the United States where the mother was unlawfully present and the father was neither a U.S. citizen nor a lawful permanent resident. So that's one category. And then the second category is the children who are born where their mother's presence was lawful but temporary, and the father was not a citizen or a lawful permanent resident. So you could see potentially a situation where the Supreme Court says, based on sort of our historical understanding of what this amendment was trying to do, that there would be no birthright citizenship for children who sort of fall in the first category, but there could be birthright citizenship, or there is birthright citizenship for individuals who fall in the second category. So that would be an example of a mixed ruling where the government gets some of what they want, but not all of what they want.
Got it. And that kind of goes back to what Jennifer said at the outset, which is this kind of that highlighted language, Jennifer, you mentioned, subject to the jurisdiction thereof, whether that kind of could be interpreted one way or another to come to a mixed ruling.
Yeah, and I think, Arjun, the first category you said was probably unlawful, right? Unlawful aliens. I don't want to call it unlawful people. The second is people who are kind of traveling through, whether it's on a visa or not. And my view on that, right? And I think the reason that lawyers are so focused on these exceptions is because the impact of the decision differs based on what the reasoning is of the Supreme Court. So if the Supreme Court says birthright citizenship, everyone can get it, except if you're undocumented, that ruling affects a different set of people that if they say everyone with a visa, a work visa, a tourist visa, if anyone has a visa here, if the mother has a visa and the father's not a citizen, that you can't get birthright citizenship. And just to, I know there's been some comments on this, but the policy concerns, right, at least that have been articulated in the public are on the first one, it's about undocumented, I think the right would call it illegal, but undocumented people in the United States. And I know that that is, kind of a firestorm of an issue, but clearly that first category is directed at people who in America are angry at having undocumented workers. I'm going to say workers because most of them are working in the United States. And then the second sort of category, and they are delineated separately in the executive order, and I'll comment on that in a second, but the second bit of it is addressing what people have called like birth tourism. There was a comment about it in the Q&A. And the prediction that President Trump has made is that the second one will not go his way. He tweeted after he lost the tariff case, and that was relatively recently, he tweeted on Truth Social, and I'll just quote from him. The next thing you know, they, meaning the Supreme Court, will rule in favor of China and others who are making an absolute fortune on birthright citizenship. And note that he didn't say that they'll rule in favor of unlawful immigrants or undocumented workers. He said, we'll rule in favor of China and others. And what that's signaling, at least to me, is that he's predicting that he's going to lose on the second broader category. That if you have a valid work visa or tourist visa and you're here and you happen to have a child, that doesn't deny your child citizenship in any meaningful way. And that would not fall within the precedent. He doesn't think Supreme Court would go that far. But he's probably leaving open the idea that the Supreme Court would eliminate birthright citizenship for undocumented people. And so if both parents are undocumented, the kids are similarly stateless. And I think that to me, at least, like the downstream consequences are really kind of tragic for the kids. And obviously, but it is a national moment where when there is pressure on a nation, whether it's economic, whether it's because of a pandemic, when there's pressure on a country, the first thing people do is push away the people they think shouldn't be here. And that applies both if you're Asian American and not Asian American. There's certainly a lot of Asian Americans who don't agree with legal immigration. There's certain Asian Americans who do agree, right, with undocumented workers. And I think that that first category is narrower, at least in people's minds, and might be narrower in the Supreme Court, and is what people think that the Supreme is sort of most at risk. The second category, because President Trump has tweeted himself, I think I'm going to lose on that one. Doesn't mean it won't happen, but seems more unlikely to happen to me if I were kind of calling it. In terms of predictions. We obviously don't know for sure, but it seems like the first category is what's really at issue here, from at least the president's perspective.
Got it. No, thank you, Jennifer. Maybe you can help frame for this audience, and I know we have many non-lawyers. Like, if we think about the oral arguments in 2 weeks, I mean, what should people be looking for? I guess you can listen to it live, but like, can you help kind of explain how the oral arguments kind of guide or give some sense, or it's not always clear.
Yeah, so
the viewpoints of
I'll
the
just preface with it. I didn't clerk at the Supreme Court, but I clerked in appeals court in DC. And the way in which, these things get briefed is that there are clerks who are like young law students for each of the justices. They will read all the briefs and prepare what's called a bench memo for the justices. The justices will then review the bench memo typically with their young law clerks and come to a decision in their own head as to where they think it should come out. It may not be fully formed, it may not be written in stone, but there is a writing that sort of documents where the justice will probably come out. And then at the oral argument is the first time that the justices really speak to one another about the case. There's sort of an unspoken rule, or maybe it's now formalized in the IOPs, I'm not sure, but there's an unspoken rule that justices don't get together and decide a case before the oral argument. That's kind of like putting the cart before the horse. So when the justices go in, and there's no other court other than sitting en banc, which is like kind of rare cases where, as a matter of course, there's so many justices or judges, right, who are sitting all at one time. Yeah, so it's a really intense environment, but the goal of oral argument is for each justice to convey to the others and try to persuade people, the other justices through their questions, of their position and then the veracity and persuasiveness of their arguments. So you'll see justices throw softballs and hypotheticals to the position that they like or don't like, depending on which way they'll come out. And we know from the procedural history in this case, because there was a kind of skirmish over whether there could be a nationwide injunction of this executive order, that some of the justices have lined up already sort of anti this case. And I'm not going to show the slide, but I can just tell you that the only three dissenting justices, right, who wanted to kind of hold at abeyance this executive order were Justice Sotomayor, Justice Kagan, and Justice Jackson. The conservative or kind of Republican nominated or appointed, I would say, nominated justices, Justice Barrett, Chief Justice Roberts, Justice Alito, Justice Gorsuch, Justice Kavanaugh, and Justice Thomas all voted that you couldn't use, that one court couldn't hold in abeyance, this executive order all at once. And if you were to go down kind of just like the political like divide, people think that that's how this case might go. But that doesn't mean it will, because at the oral argument, they'll talk to one another through the oral argument. So it's sort of like the way I think about it, it's like watching your parents fight, but you're like at the dinner table and you have to sit through all of it and watch it. That's what it's like listening to oral arguments. And there's going to be a blog on what's called SCOTUS blog, SCOTUSBLOG, and there's going to be commentary on it the way that you would see commentary on a sports game or like the news or anything else, like on the Oscars. Like there might be a live stream, but people will comment on it and say, okay, Justice Barrett's definitely going this way. My belief is that the more moderate kind of conservative justices, Chief Justice Roberts and Justice Barrett, won't eliminate birthright citizenship in total. It's not consistent with the text, in my view, but they may kind of carve out some exceptions that the government wants, and maybe that will be considered a win by the government, even if it's a narrow exception.
Jennifer.
Yeah, and
I know we're coming up on time here, so I see questions here, and I want to be mindful of our time. I'm going to just go and there's two that Jennifer raised or addressed at a high level, but maybe others can chime in. Wendy, there was one that was raised about the treatment of birth tourism in America, and the other one was on the treatment. And again, Jennifer spoke some about this, about the undocumented peoples who are targeted by this resolution. Could you speak to both those questions, please?
Yeah, so to the first question that was asking about the prevalence of birth tourism, well, first of all, as Jennifer mentioned, people who are in the U.S. As tourists fall under the same category as the other people who are on legal visas, people who are on student visas, work visas. So it is unlikely that the Supreme Court would carve out would distinguish between people on tourist visas and people on, say, a student visa, an F1. So we really are looking at those categories together as a whole. But specifically on the sort of more ideological argument about why shouldn't we have this executive order to discourage birth tourism, I think the answer is that there are already laws against immigration fraud. There are various ways you can commit immigration fraud, and we have laws against that, and they are enforced. And typically, when people are found to have committed immigration fraud, there are repercussions for that individual. What we typically don't do is punish their children. And like Jennifer said, the downstream consequences of this is that there could, if enforced, there could be people who are left stateless, people who, I mean, there's also just so many consequences at an administrative level. There are going to be differences state by state. Some states are going to enact protections for the people who are impacted by this executive order, while others don't, which will lead to chaos crossing state lines, people probably attempting to cross state lines to have children. And it's just not, it's not a sensible or logical way to regulate immigration by essentially punishing the children that are born in the U.S. And to the second point about I think what the question is aimed at is asking, isn't this executive order just aimed at the children of the undocumented people in the U.S.? And the answer, as my co-panelists have said, is no. The executive order, if you look at the language of the executive order, it doesn't stop at children of people who are unlawfully in the U.S. It explicitly calls out children of people who are in the U.S. temporarily. It explicitly says people who have a visa, a tourist visa, a student visa, or a work visa. Those categories are in there for a reason. It's because the government, or the president, when he signed this executive order, when this executive order was put together, they specifically thought about those categories, and there was a deliberate decision made to include those categories of visa holders in this executive order.
Thank you, Wendy. I'm going to ask another question here for the group. And maybe Arjun, this is for you. If the Supreme Court were to follow along with the executive order, what would this mean for denationalization efforts, right? And this is kind of exactly what happened with U.S. versus thin. This is what we talked about as a practical. I mean, we're going to, and Wendy kind of touched upon this, there'll be a lot of uncertainty about what states may do here, right? I mean, we talked about voting, you talked about juries. Just kind of how would you even implement this? So maybe we can kind of go a little bit more detail on some of what happened, not just with Flynn, but also with the women that were denationalized. I remember there was the case in our brief regarding American women, right? Not just foreign born or non who were denationalized. So maybe you can touch upon that question.
Yeah, that was about the Expatriation Act of 1907. So we use the example of Asian American women who married foreign nationals, like a Chinese national, for example. So as a consequence of the Expatriation Act's terms, that individual who previously had citizenship in the United States lost her citizenship as a result of her marriage to a foreign national. And it was particularly pernicious for Asian Americans because at the time, the rule for naturalization, so you're imagining a scenario where maybe they married a foreign national, got divorced, and then wanted to return to the United States, it would be difficult for them to be able to get U.S. citizenship again because the rules on the books at the time were very limited in terms of which individuals could qualify for U.S. citizenship through naturalization efforts. but I think to get back to the question, um, I would say that uh, what this means for denaturalization efforts, I think part of the sort of downstream consequences will turn on the nature of the reasoning of the Supreme Court's decision. So they could uphold the executive order, but do it in a really narrow way that would sort of just apply to these categories. That would be drastically different, I think, than a Supreme Court decision that maybe launches a broadside at the notion of birthright citizenship generally that goes beyond just these two categories. And if that's the case, you could potentially see a situation where the federal government or even state governments, like I had mentioned, would take that and sort of run with it. And obviously, I think those efforts would be challenged in court and would, courts would have to issue decisions with respect to those specific efforts. But I do think the downstream consequences sort of depend on the nature of the opinion, which we won't know until it obviously comes out.
Got it. I know we have a couple more questions. I don't think we'll get to. I'll do one more here. If this is toss, what are the risks for Chinese Americans from prior generations being deported? I think the way I look at the executive order, it's perspective, right? Although there's something's constitutional, either it is or not, but the way they drafted EO at least is that it's intended to be prospective 30 days post enforcement. So maybe the at least from the Trump administration perspective, it's not meant to be retroactive. Again, whether I can say something constitutional only one way, not the other, seems kind of specious, but that at least is the way I interpret.
Yeah, I think the way it's written is like after the EO 30 days later, no government official can then issue a passport, or citizenship papers on behalf of someone who falls within like an exception, I guess, to birthright citizenship. So it
Right.
wouldn't take away people, but if to the extent that you don't have citizenship now, I think that's a potential issue down the road.
Yeah,
Yeah.
maybe the last question here, which is
So sorry,
one of
just
my-
to just to add to that, I think the real issue with the prospective versus retroactive implications is that if the Supreme Court does find that the executive order is constitutional, as in it is fine under the 14th Amendment, then what the Supreme Court is holding is essentially that birthright citizenship under the 14th Amendment does not exist.
Right.
And there is no way to only prospectively
Right.
get rid of the 14th Amendment. It just means that everyone who has ever obtained citizenship through birthright is now at risk of denaturalization if a future administration decides to take a look and decides to initiate denaturalization proceedings.
Yep, understood that. I think that risk certainly is there. I know we're coming up on the hour. Cindy, I mean, we do have lots of questions here. I don't think we'll be able to get to all of them, but mindful of everyone's time here. But I do really want to thank Jennifer, Arjun, and Wendy for their very cogent comments to the audience today.
Yeah, well, thank you, Tony, and also Arjun, Jennifer, and Wendy for this very nuanced and informed discussion. These are exactly the kind of conversations that is going to help us create an environment that is more comprehensive so that we understand the legal and policy issues that are shaping our community. So as we wrap up, very quickly, I would like to give each of our panelists let's say 30 seconds, if there's any lasting point or something that you want to leave behind with our audience.
For me, it's just I like the last question by the anonymous, the 351, which is the legislature still has power, right? 14th Amendment was created in part because of the people. You yourself can vote and get your voice heard. And if you end up in legislature voting for a position, you can shape this country. The Supreme Court isn't the end all be all. Separation of powers means that ultimately power rests in the people, and that really means legislatures.
Thank you, Jennifer. Wendy?
I think the takeaway, and from having worked on this, is that this is an issue of great importance and great relevance to our community, to the Asian American and Chinese American community. It's easy to think that if you've been in this country for generations, that this doesn't really apply to you. But we are only a couple of Supreme Court cases, a couple of laws away from losing what our ancestors have fought for over the last 125 years.
Thank you, Wendy. How about you, Arjun?
Reflect that same sentiment. I think at the end of the day, this case is about more than legal doctrine. It's about who gets to feel a sense of belonging in America. And I think when citizenship becomes uncertain, The harms are real, they're immediate, and they're often going to be generational. So that's why this case matters so deeply to so many people in the Asian American community. It's why the opportunity to work on this amicus brief resonated with me. I think it's ultimately why protecting birthright citizenship under the 14th Amendment matters so much.
And Tony?
Yeah, 100% agree with all the speakers before me. I mean, this matters to all of us. I think the Asian American community, we are, so affected by kind of what's being debated in Congress, on the news with the president, and our last bastion of protection is the Constitution. And like I said before, for me it's personal, like it is for many people on this call today, where I wouldn't be here but for birthright citizenship when my parents came to America. So I would encourage everyone to stay involved, to pay attention, to listen to the April oral arguments, as Jennifer said. Listen to the questions. Hopefully that will give you a sense of where folks are leaning to. Thank you to Committee of 100 for leading this very important discussion today.
Thank you. Again, thank you to all our panelists and for all of those who joined us today. If you did find the discussion helpful, please share this series with your colleagues and others that you believe may also be interested in this topic. As a reminder, we do have these conversations monthly, third Tuesday of every month. And, there will be that survey. We encourage you, please, please, please fill them out so that we can tailor these segments to address what the community wants. And then if you are in position to do so, please feel free to support our work at donate.committee100.org. We have another wonderful webinar coming up in 2 weeks on March 25th, where we will be sharing the second part of our State of Chinese American report. Looks like my colleague has just put the link to register for that webinar in the chat. So please register for that event. Again, thank you everybody and have a great rest of your day.